Gentlemen, now it's time for the nation's sharpest opinion. Ladies and gentlemen, 80,439 are all pending cases in the Supreme Court as of 2023. It was an all-time high. As opposed, ladies and gentlemen, as opposed to the Supreme Court in the United States of America that heard about 70 cases a year, the Supreme Court of India is estimated to hear 700 plus legal matters every single day. Ladies and gentlemen, that's just phenomenal. But dear viewers, for a system so committed, so robust to deliver justice to the people, is it a waste of time to flood the courts, inundate the courts, all kinds of petitions and PILs? Especially those which are settled matters by the parliament, by the executive. Just waste the time of the court in that. When there are so many important matters, if every action of the executive starts getting questioned in the courts, does it not raise different issues, serious questions? Today, ladies and gentlemen, the Modi government was once again reiterating that Rohingyas have no fundamental right to reside in India. Of course they don't. If they're illegal infiltrators, they don't have a fundamental right. What is there to discuss? Debate. The government impressed upon the honorable courts that the domain of policy and legislature are domains left to the right of parliament, and I totally agree, and so does the court, I'm sure. So does the court. Policy is for the government to do. Otherwise, what's the point of having a government? What's the point of having parliament? Because in the year 2022, the very Supreme Court that heard the PIL today is the very same Supreme Court which in the context of Rohingya said that there are some issues best left to the executive. So settle the matter. So the honorable courts are acutely mindful that the domains of the executive and the judiciary are exclusive and coexist independent of one another. But all settled matters go to the courts. All activists go to the courts. Every day there are thousands of petitions. All petitions will be discussed, debated as high constitutional matters. The courts have so many important things to do, rather than keep hearing whether Rohingyas should have a right to live in India. And there is an increasing discussion these days about whether there is a thrilling trend of opposition parties directly or through proxies rushing to the courts to settle matters that they cannot or address or counter politically. Now, for them to do that, if these opposition parties or groups want to decide policy matters, there is a simple way. Fight the election, get elected, have the numbers in parliament, pass your laws, decide your policy, run your government. But why make the courts do what you can't do? And whether the courts should entertain these things at all or not, or dismiss a large number of petitions as frivolous petitions, especially on matters which are purely under the domain, command and prerogative of the executive of India, the democratically elected government of India, the democratically elected policymakers of India. Because the government is now increasingly being brought in, whether it's the Rohingya case, whether it's a CA case, whether it's the election commission appointment, whether this or that or this or that. Constantly, the government has been of late reiterating and impressing in the courts the right of parliament to govern, the right of the government to formulate laws, the right of the government to execute policy, because they have been elected to do it. We are going through a general election. And as a citizen, I also believe that many people have started to file petitions which are quasi-political, which I believe are quasi-causes of the opposition. And this matrix of NGO workers and rent-a-cause activists have a mirroring agenda to the opposition causes. So then the question arises on whether the courts can or should entertain PILs by this brigade at all. I'm not talking about a specific case, but this is the broad trend. Because the unelected quasi-opposition, wearing the hat of NGO activists, will start playing the role of the opposition, and the courts will be asked to settle scores that the opposition cannot in parliament. That is not the right way to go about it. That is not right for the country. That is not right for our democracy. And that is my firm view.